Good morning, ladies and gentlemen, and welcome to the Attorney General's office. Today, I think, was a historic moment for women in the state of New Mexico. As I remarked to the Supreme Court this morning, women in every community in this state have a fundamental right to access reproductive health care, and they are looking to this court to affirm that right and to ensure that when they choose to make a decision that implicates fundamentally their families, their futures, their health, and their bodies, that they are entitled unequivocally to the equal protection of the law. I also think it's an auspicious occasion because it is, in fact, the 100th anniversary of the first time that the Equal Rights Amendment was introduced in the United States House of Representatives. And I really appreciated the opportunity to present our argument before the court. As you know, there are two fundamental reasons that these local ordinances violate New Mexico law. First, that they are preempted under our state statutory scheme and specifically by the passage of House Bill 7 from regulating the practice of medicine in any way, specifically with respect to reproductive health care. And it was clear to me from the questions that the court had that my sense is that the court is very much aware of and supportive of the idea that local ordinances and local governments cannot have the kind of effect that respondents were hoping for. The broader constitutional question, specifically whether or not the right to reproductive health care will be guaranteed under the unique aspects of the Equal Rights Amendment, is, I think, an outstanding question. But it appeared to me that the justices were very much grappling with that issue. I found it really informative that Justice Thompson in particular had honed in on the question for respondents about whether or not they'd actually passed any kind of ordinance that regulated the access that men in their respective jurisdictions had. And the answer to that question was no. And what it does is it really highlights the fact that as much as we've made progress in terms of what Justice Minsner had referred to 26 years ago as an evolving concept of gender equality, that we still have a long way to go in this state. But I was, on the whole, very encouraged by their responses, by their questions, by their attention to the arguments. And I am extraordinarily pleased today to be joined by allies in that fight. First, my co-counsel, Becca Gallegos, who represented Planned Parenthood. And at this moment, I'd like to turn it over to Adrienne Manzanares, who also, I believe, is the CEO of Rocky Mountain Planned Parenthood, to give her thoughts on the argument that we heard and the questions that were offered by the courts. Adrienne.
Thank you so much. Thank you all so much for being here. I am Adrienne Manzanares, the president and CEO of Planned Parenthood of the Rocky Mountains. We operate and provide services and education, not only here in New Mexico, but also in Colorado, in Wyoming, and in Southern Nevada. And when we have a moment like this in history, it's important to know that while the eyes may be on New Mexico, the entire country truly is affected by what happens here. And I want to just take a moment to thank, of course, Attorney General Torrez and our amazing legal team for taking up this issue and really shining a light on two important things. And the first one is that we all need to remember to thank our healthcare providers. The amount of work, the stress, the gravity of losing the equal right for abortion care across the country comes on the heels of a wide-ranging impact of the pandemic. Our healthcare employees have been at it nonstop, providing care no matter what to anyone, regardless of their beliefs, regardless of their zip code, and in these days, regardless of how far they've had to travel to get that care. I also want to take a moment for our second concern and thank every single patient who is strong enough and brave enough to come into a health center to get the care that they need under this kind of legal attacks, of political attacks, the shame and stigma that has perpetuated now, especially since the Dobbs decision. It creates a hard psychological barrier for folks to get the kind of care that they need. And when we have legal champions like this who can come before a Supreme Court and make the claim that we all know to be true, that New Mexico has said over and over again. Healthcare providers, you are safe here, you practice your medical standards of care here, and patients, local and from across the country, come here to New Mexico, alone, with your family, however you may need to get into our health centers. We will welcome you with open arms, because here in New Mexico, we have said it over and over again. Our partners have been on the ground organizing for decades to make it very clear that in New Mexico, abortion care, reproductive health care, sexual health care is a human right. It is part of the full spectrum of health care that we all have the responsibility and the duty to protect and to provide in this state. Thank you again so much for your time, and I'm delighted to be joined by our ally from the ACLU.
Thank you. My name is Ellie Rushforth. I'm the managing attorney for reproductive rights and gender equity at the ACLU of New Mexico. The ACLU has been a longtime defender of reproductive freedom in New Mexico, and we're honored to submit an amicus brief in this matter, and we're so grateful for the Attorney General for taking on this fight, and for our longtime partners who are in this room with me today. We do not have to imagine how difficult and how complex and how dangerous ordinances and attempts to interfere with access to not only abortion care, but reproductive health care actually is. We see this every single day across the country, and truly, we see it in New Mexico. We are a rural state with a general lack of access to health care. Add on additional barriers to seeking reproductive health care, in particular abortion care. I simply cannot stand when out-of-state interests attempt to tell New Mexicans what our values are. We value and respect everyone's decision to make their own healthcare decisions about their lives. We know that the decision of if, when, and how to have a child and to parent those children in safe and sustainable communities is one of the most important values we have here. And I'm proud and honored to be a part of this fight, and we are not done.
So I know there are probably a number of questions, and so I'd open it up to members of the press for any questions you may have regarding today's argument, the briefing, or anything else.
I certainly have some questions, sir. Thank you for all the briefing.
Would you please identify yourself?
Sure. I'm Robert Knott from the Santa Fe New Mexican. Is this on?
Yes.
Great, thank you. Much of the argument kept coming back to this issue of local versus state control with an overlay of, do they even have the right to adopt the Comstock law? I don't know the answer to that last one. Do you know whether, first of all, do local ordinances have the right to just say we can adopt the Comstock law? There seems to be a big debate about that. But take a little farther with the whole issue of state versus local and how this could expand to other issues beyond reproductive rights or abortion care.
No, and that's a great question, and if you'll recall, that's part of what I was referencing when I used the analogy of cannabis, for example, because New Mexico has made a decision with respect to that issue that legalizes the possession, consumption, distribution of cannabis. And as you know, that is still something that's prohibited under federal law. And what it really does is sort of identify the distinction between where and how federal law gets employed and whether or not it has any effect on the local decisions that we make at the state level. What I was trying to articulate for the court is that if they allowed local governments to identify some interest in federal criminal law to justify coming up with some alternative scheme, you would see a patchwork of regulation that impacted not just healthcare, but all sorts of things. And fundamentally what this is about is at what level these decisions are allowed to be determined and allowed to be made. Under our Constitution and our statutory framework, local governments can engage in legislation that impacts local issues and only local issues. But when the state has acted as they have in the sort of the area of medical practice and licensure, they have preempted local action. That's what that argument was about preemption, where the state has said over time, we are going to control when and how physicians can go about practicing medicine, and medical facilities can be licensed, and nurse practitioners. There is a comprehensive scheme that leaves no space for local governments to do that. And if that weren't enough, the passage of House Bill 7 makes it explicitly clear that local governments don't have the authority to regulate the practice of medicine or do anything that's contrary to the policy priorities that have been established at the state level. It seemed clear to me that there was a solid basis of support in the Supreme Court for just that proposition. What we were attempting to do, and I think we'll have to wait and see what opinion is rendered by the court, is to go further than just the preemption issue and start talking about the deeper and I think more consequential elements of what our state constitution affords in terms of rights. And the reason that's so important is that for 50 years, women in this country, providers in this country, could rely on Roe and Casey and subsequent decisions, and they understood that at the federal level that right was protected. That is no longer the case because of Dobbs. And so now it is falling to state courts to articulate and identify whether or not there are constitutional rights, separate and apart from the legislative protections that we spent a lot of time talking about today, that women can and should be able to rely upon. I think at least there were certain justices that seemed very interested in exploring that concept. My hope is that we will sort of see an expansive rather than a narrow ruling in this case, but we'll just have to wait and see. One of the other things that I think came up was a discussion about who should determine the standards of medical care. Right? I don't know if you remember that conversation, but it seemed to me that the justices were very troubled by the fact that politicians, frankly, that judges would be inserting themselves into the conversation about what constitutes the appropriate standard of care. And I think it really sets up a stark contrast. Think about what's happening in Texas right now. Right now in the state of Texas, my counterpart took a totally different approach and filed an action in that Supreme Court and asked the Supreme Court to involve itself in the state of Texas in what the appropriate course of treatment should be for a woman with a non-viable pregnancy. And I think from a value standpoint, the thing that is so troubling about that, and part of the reason we advanced the arguments that we did, is that my fundamental view is that elected officials and judges should not be involved in that decision. That's a decision that should be made by a woman, in consultation with her physician, in consultation with her family or her faith leader, whatever it is, and whoever it is that she decides to include in that decision, it's for her to make. And it's in consultation with whoever she decides needs to be included in it. And instead, what you saw and what you witnessed in Texas is a bunch of elected officials and people in robes making a determination to overrule what a woman and her physician have decided to do as the best course of action. And that's fundamentally what sets us apart as New Mexicans. We are not Texas. And our argument today was centered on the fact that if nothing else, we're not going to allow city managers and county commissioners and other people to start getting between women and their doctors.
I feel like you answered everything. Thank you. But I'll still ask. But I feel like you just did everything in a nutshell, and I just have my notes here. But I was just gonna say, what rights do these local southeastern counties have when abortion is already legal in New Mexico, because we know our women are safe here? Can you speak to the rights of protection that they have? Which I feel like you already did. I promise you I wrote this already, right? And why this was a historical moment in court today.
Well, I think the fundamental point is that their local governments just simply don't have the authority to operate in this space, to regulate healthcare in general, to regulate the practice of medicine in general. They certainly don't have the right to do so in a way that singles out one procedure, specifically a procedure that is utilized, frankly, by women but not men. And that was why we went down that line of discussion with Justice Thompson, where he asked respondents to articulate what rights what medical procedures have you regulated that only affect men? And the answer is there are none. And what that does is it points us back to this NARAL decision that was articulated in 1998 in Justice Minzner. And I would encourage all of you to look at that, because it starts not just by talking about the textual differences, but the historical legacy of this state and of this country, where there was a time and place, sadly, where women could not vote, they could not hold public office. There were special exemptions for marital rape, a whole host of other things, where women were treated as second-class citizens. And in examining whether or not public funding should be available for medically necessary abortions, Justice Minzner came to the conclusion that that was a form of gender-based discrimination, that it was subject to strict scrutiny, and it couldn't be justified. What we did today was basically have asked the court not to examine that more limited question of funding and availability, but the threshold question of, do women have a right to access? And that's why we were so focused on getting them to do that. And in particular, it's in the backdrop and in the context of the Dobbs decision, because think about how much that has unsettled everything. One of the sort of ironic things about the Dobbs decision is, number one, there was this sort of conservative remark afterwards where, well, we're now going to just let states decide. Well, guess what? New Mexico has made that decision, and we're still having this fight. So this idea that we were going to put things to rest by reversing and stripping away a right that women and providers had counted on for 50 years is just false. What today's hearing is about the next iteration and the next evolution of this fight. And over time, what I would hope is that we have an opportunity to appear again before the United States Supreme Court and offer them an alternative way of viewing these types of regulations, not just on due process and privacy grounds, but on equality, on the equal treatment of women, because that's fundamentally what today's case was about.
I have two things, actually. One question, I would just like some more commentary on what you felt like emerged as your strongest argument. Of course, there was the constitutionality piece, House Bill 7 piece. So I'd like that, and I'd like some comments, too. There were multiple times that I heard during the hearing this parade of bad that could come in the future. Will you give some more insight into what that actually could mean, and not just in New Mexico, but nationally?
So from my perspective, and I would love to hear the perspective of my co-counsel, it seemed to me that there was a strong consensus that House Bill 7 simply preempted local action. I think that the court is, based on their questioning, based on their response to some of the arguments that were made, that there's a recognition that this is simply foreclosed to them. And so I wouldn't be surprised if there was a narrow ruling. What I was trying to get the court to grapple with and understand is, even if they decide not to reach the constitutional question today, we're going to keep coming back, because the attacks, as Rebecca pointed out, are going to keep coming. The ways in which people are creative about attacking this right, there's no limit to that. And one of the things that I tried to do in the rebuttal argument is highlight just a couple of things we're worried about. Right now, I'm very concerned, number one, about data brokers. Most people don't realize that when you use a phone and you accept all those terms of service and terms of agreement, what you're doing is you're enabling a third party to track your movements. What if that movement tracks you to an abortion clinic in the state of New Mexico and is subject to a subpoena by somebody out of state, in a state that prohibits that conduct? It was revealed on I can't remember which national paper had covered it, but it was revealed recently that pharmacies, CVS and others, national pharmacies, have been turning over prescription records. Most Americans, and certainly most people in New Mexico, are unaware that by just the issuance of a subpoena, which, by the way, doesn't require the judicial review, doesn't require independent review of those standards, that we have people in this country who are sending subpoenas for records for prescription drugs. Those are just two of the examples of the types of information that people out of this state are going to be looking for. And it's why I thought it was important to highlight for the court that if they go with just a preemption argument, just the statutory argument, there is the strong possibility that we will be back again. We will come back again. And one of the commitments that I make here and make to the allies that we have in this space, I will keep coming back and making this argument as many times as necessary. My hope is that we can convince the court to start engaging and using its independent constitutional authority to craft broader protections for women so that we don't have to come as frequently and as often, and just to settle the question once and for all. Are there any other questions?
Thank you. Sir, I believe it was Ms. Baca. Was she representing Hobbs? Am I right?
I don't.
Ms.
actually
Chacon,
don't
pardon
recall.
me.
Okay.
Who said we're not against abortion. She actually said that. You
Yeah.
probably remember that.
Yeah.
What's your thought of that comment pertaining to this entire case right now?
I frankly thought it was laughable, and I think the court thought it was just, the Chief Justice said, all you have to do is look at the title, look at the definitions. I mean, to try and go before the court and say, well, this is about business licensing, that wasn't going anywhere, right? That dog won't hunt. And the judges weren't buying it. And so I was a bit surprised that they didn't just own the fact that they were specifically targeting abortion, that they were trying to rely on federal law in a way that they thought conferred authority on them that didn't. But this idea that it wasn't about abortion was, I don't think, something that the Supreme Court is willing to accept. Okay. Thank you again for your attention to this. I really do appreciate it. Thanks.
Thank you so much. Oh my gosh. Yeah.